Hi everyone. Very good evening to you all. Hi Shruti. Hi Richa. Hi Meeta.
Hello, ma'am.
Hi, how are you all doing?
Great, ma'am.
Great. So progressing well on the ACL3 course. Were you able to submit all your assignments or anything that needs to be resolved? Just let me know.
Sure, ma'am.
Sure. Hi Richa. All good from your end as well? So all submissions done or it's still pending from your end? Anyone, late submissions or on track for everyone?
Ma'am, I am lagging behind, but I will do that by tomorrow, end of the day for sure.
Yeah. So we would be wrapping up the course in another, I think, 4 weeks or 5 weeks. And so just try to submit all your assignments before that, be better, so that we can issue the certificate on time. Okay. For
Yes,
all.
ma'am. Yes, ma'am.
Okay. So maybe we can begin with our session. Hi, and a very good evening to you all. Today we'll be having our final session on insolvency law. This course is part of our ACL3 program, and it's also one of the featured courses for this month. Also, for the schedule for the next classes, we have corporate fraud coming up and also the insider trading. And the dates I think we have already put on our portal. For 3rd of August, we would have insider trading, and on 20th of July, we would have a session on corporate fraud. And for today's session, we'll be discussing the resolution plan and resolution applicant. And we have with us Mr. Abhishek Sharma, his partner at Dental Link Legal. Abhishek has over 13 years of experience in handling dispute concerning the aviation sector including airports and civil and commercial disputes in various fora, including the Supreme Court of India. Also, let me tell you all that Abhishek has been integral part of all our ACL3 programs cohorts as an instructor for all our courses on insolvency. It's always great to have you on our platform, Abhishek. Welcome again, Abhishek, to EBC Learning. Now, without any further delay, I'll just hand it over to Abhishek. Abhishek, over to you. Thank you.
Thank you. Thank you so much, Achal. Hi, Shruti. Hi, Sayam. We have a
Yeah,
small
hello.
group.
Yeah.
Uh,
No, sir.
Hi. So I've at least I'm of the view that it's always quality over quantity. So happy to be part of this intimate group. I have a presentation with me. I'll run you through the slides. I'm relying upon some judgment, so I will have to bore you there, give you the facts, etc. But I will try and share my experience, my learnings with you, rather than making this a dull and dry session where I tell you what the law looks like, because you can always pick up the book and learn the law. So a very brief introduction. I'm Abhishek. I am about 17 years into law practice. I am essentially a disputes lawyer. In terms of sector focus, I do a lot of work in the aviation space, including airports. I do work for infrastructure companies, including power, transportation, etc. And a big chunk of my practice is also insolvency. So on the insolvency side, I'm both on the dispute side as well as on the advisory side. So with that out of the way, I'll start with today's session, and I will essentially be dealing with what is a resolution plan and who is a resolution applicant. While I had thought originally that we could do Q&A at the end, considering that this is such a small session, I mean, even if you want to step in, feel free to. With that out of the way, I'll quickly start with the presentation. So the first slide that I'm dealing with is what is a resolution plan? Essentially, a resolution plan is I will, of course, in the next slide, deal with what is the entire life cycle of an insolvency process. And then I will eventually sort of stop where we come to the resolution plan bit. But essentially, a resolution plan is a document by way of which a resolution applicant expresses its desire to take over a corporate debtor. And it includes the various terms, conditions, which the resolution applicant will implement in taking over the corporate debtor. Very briefly, I'm sure you've already had lessons in the past where you've been taken through the entire corporate insolvency resolution process. And I will just take 10 minutes because I can never emphasize this enough. I think we should know the life cycle of the entire process. And then, of course, we'll come to the specifics. So essentially, initiation of corporate insolvency can be in three ways. It can be initiated by a financial creditor under Section 7. It can be initiated by an operational creditor under Section 9, which has to be preceded by a notice under Section 8, or it could be by the corporate debtor itself under Section 10. Now, the best known insolvency case, which is one of the most recent cases, is the Go First case, which was a case of Section 10, where Go First itself went into insolvency and tried to initiate, requested the NCLT to initiate insolvency against itself. Now I'm going slightly off topic now, but let me tell you, because I was closely involved in that matter. Let me tell you how the lawyers for Go First, what was the issue there and how they tried to initiate insolvency. Now there is, in aviation law, there is something called the Cape Town Convention. India is a signatory to the Cape Town Convention. Go First had a large fleet of aircraft which had been leased to it by foreign lessors. Now, in terms of the Cape Town Convention, if there is any default in an aircraft lease, so if an airline fails to pay its lease rent, the lessor who owns that aircraft can file a request with the regulator, which is the DGCA, and seek a direction that these aircraft be deregistered. Essentially, in order to take back possession of the aircraft first has to be deregistered. So the Cape Town Convention says when the owner of an aircraft, that is the lessor, makes a request to the regulator will process that request within 5 days. And if the regulator is convinced that there has been a default, then he has to deregister that aircraft. Now in Go First, there was an admitted case that there is a default. What Go First tried to do was they realized that there is a moratorium provided in the insolvency code. If that moratorium kicks in, then they will be able to stay in possession of those aircraft. So Go Air filed a Section 10 insolvency petition. And the moment this petition was filed, the aircraft lessors realized that as soon as this petition is admitted, the moratorium will come into play. Then they will not be able to repossess aircraft. So on the very same day, almost all lessors file this application for deregistration with the regulator, that is DGCA. And the DGCA was to decide this request in 5 days. But before the expiry of 5 days, Go First had convinced the NCLT to admit the petition. So the result was that the moratorium came into play. Those 5 days had not lapsed, so the deregistration could not take place. Therefore, all aircraft remained in India and remained registered to Go First. So that was a tactical ploy which was adopted by Go First. And of course, that case went on for a year and a half. And now there is some clarity where the High Court has said that the moratorium will not apply to these leased aircraft, and the lessors have started to take these aircraft back. Having gone slightly off track, I'll just come back to the issue of initiation of CIRP. So I said the CIRP can be initiated under 7, 9, or 10. What happens once the CIRP is initiated? Immediately after the initiation of the CIRP, the interim resolution professional assumes charge of the corporate debtor. The first thing that he does is he invites claims. The reason why the first thing he does is invite claims is because it is critical that you have a committee of creditors in place. Unless you have a COC in place, you cannot effectively run a CIRP process. Because all major decisions, effectively, the COC is the mother that nurtures the baby of the CIRP. So that is why, unless you know who are the claimants, who are the creditors, and you have clarity, you cannot constitute the COC. That is why the first step in any CIRP process by an IRP is inviting claims. So after the CIRP invites claims, he forms the committee of creditors. Now the committee of creditors gets busy with the process of resolution of the company. But parallelly, there are other actions that are taken by the RP. For instance, he files an application if he finds that there are any transactions that are preferential, undervalued, or extortionate, he will file those applications. While simultaneously, he also tries to revive the company by inviting resolution plans. So the first document that the RP issues is called a request for resolution plans, by way of which he requests all interested parties to submit their plans. Once these plans are submitted, the IRP carries out an analysis of these plans, and he has to return a prima facie finding as to whether these plans are compliant with the law or not. If the IRP finds that these plans are compliant with the law, then he will place these plans before the COC for their consideration. Now, the COC, before it votes on these plans, will very often negotiate with various resolution applicants. It will ask them to improve upon their plan. And then once all this exercise is over, it will then put these plans to vote. Now, if these plans receive 66% or more voting, these plans are approved. And the plan that has been approved then has to be filed by the resolution professional before the NCLT for its approval. It is only after the NCLT puts its rubber stamp on the plan will the plan become applicable and binding on the world at large. Until that stage, the plan is not binding. Now, let us presume a situation where no plans are received. What happens in such a case? If no plans are received, the only logical next step is to take the company into liquidation. So in such a scenario, the RP generally will itself file an application and tell the NCLT that there is no resolution possible. Please let me take this company to liquidation. Alternatively, there could be a scenario where one plan is approved and the plan is implemented. Once the plan is implemented, it is the end of the CIRP. However, there could also be a scenario, and there are many cases of this nature, where a plan is approved, but the resolution applicant fails to implement that resolution plan. What happens in such a scenario? So this scenario is very similar to the first scenario because the logical next step for this is again taking the company into liquidation. In very exceptional circumstances, NCLT or the Supreme Court have actually exercised their power and said that we do not think it is fair to take this company into liquidation. So we'll give you some more time to rerun the resolution process. But ordinarily, a company of this nature will, if the resolution plan is not implemented, it will go into liquidation. So with that out of the way, you can see on your screen the various timelines. I won't bother you with this. You can see the events on the left and the timeline on the right. For instance, the invitation of EOI and the publication of Form G has to be done within 75 days from the CIRP commencement date. There is a submission of EOI by a prospective applicant, which has to be done within 15 days of the invitation. There is an issuance of provisional list of PRA is prospective resolution applicants. This has to be done within 10 days and so on and so forth. So in the interest of time, I'll skip to the next slide. So one of the judgments that deals with the issue of resolution plan is a decision in the case of Binani Industries. Now, one thing that is very clear is that the NCLTs and our judicial system recognizes that the resolution process is a commercial process. It is not a judicial process. And therefore, there is ample flexibility provided to a resolution applicant to structure this resolution plan in whatever way it deems fit. So, for instance, there are multiple ways in which a resolution plan can be formulated. Just to give you a few examples, the most common plain vanilla manner in which a resolution plan can be structured is where the resolution applicant could be a company, and the resolution applicant says that I will subsume the corporate debtor within myself, and the corporate debtor will become part of me, and we will continue to do the business that I was doing, plus the business that the corporate debtor used to do. That is one manner. Another way could be where the corporate debtor says, where the resolution applicant says that the corporate debtor will merge not with me, but with one of my subsidiaries. So there are different manners and ways in which these plans can be structured. And there is most formulations which are adopted are accepted by the NCLT because NCLT thinks that it is not wise to interfere into these business decisions. And it is for this reason that the court does not spell out the shape or the color or the texture of the resolution plan. So having said that, I'll quickly come to this very prominent judgment of Binani Industries. Now, what happened in this case was that certain appeals were filed before the NCLT against an order of the NCLT passed in the CIRP process initiated by Bank of Baroda against Binani Cements. Now, the IRP filed certain applications, and the resolution plan submitted by this entity called Rajputana Properties was approved by the COC, while a resolution plan submitted by Ultratech Cement was not even considered by the COC. So this matter traveled up to the NCLAT, and the NCLAT basically framed three questions. The first question that it framed was whether non-consideration of the revised offer of Ultratech was in violation of the IBC. Number two, whether there was any discrimination against the unsecured financial creditor vis-a-vis other financial creditors. And thirdly, whether the RP has ignored any of the operational creditors' claims. So the third issue I will not delve into. But essentially, the NCLAT in this case finally held that the resolution plan submitted by Rajputana was discriminatory and contrary to the scheme of the IBC. And then the NCLAT went on to define what is resolution and how it ties in with the objective of the court. So there are 4 or 5 findings. I'll just go into 2 or 3. First of all, the NCLAT held that the objective of the code is resolution, and there is no buying or selling. So, resolution is different from buying. A resolution applicant does not buy the corporate debtor. It might eventually have the effect of the corporate debtor merging into the resolution applicant, but a resolution is different from a straightforward sale. The NCLAT also said that one of the objectives of the code is promoting availability of credit, and that the IBC is essentially for reorganization of the insolvency resolution of the corporate persons and maximization of assets. And it then goes on to deal with certain other issues which I don't want to bore you with. Moving on to the next slide, what are the mandatory contents of a resolution plan? Now, there is no rocket science here, because if you see the insolvency code, you will find that it is already provided in section 30, subsection 2. What are the mandatory contents? Now, I have some experience with resolution plans because I have pursued many of these plans for resolution professionals. And I've been successful in getting many of these plans approved. So I've actually, lived these examples. And I've pulled out provisions from plans, and I've argued before the NCLTs how the plan that I'm propagating is actually compliant with the insolvency and bankruptcy code. So one of the criteria that a plan must pass is that it should provide for payment of insolvency cost in priority to payment of other debts. Now, the rationale behind this requirement is that once a company goes into insolvency, it is often in a financial position where it is unable to pay off, unable to continue to pay its workers or employees or other operational creditors or vendors from which it might be doing business day to day. So the idea of this clause is that at least the resolution professional, the lawyers who are helping the resolution professionals, the resolution professional very often has a team. He involves other chartered accountants or business executives to run this company. If you don't pay those people, then nobody will come forth to volunteer services for a CIRP process. So the idea is to ensure that all professionals who are rendering services are paid. The second requirement is payment to operational creditors, which shall not be less than the amount to be paid to the operational creditors in case of liquidation. Now, what happens is, in case of resolution by way of approval of a resolution plan, the only creditors that vote are financial creditors. And the way the insolvency code is structured, financial creditors get a lion's share, or in fact, the entire share of the whatever is left in the company. So all the money, most often, the resolution plan will be structured in a manner where almost all the money being brought in by the resolution applicant will go to the financial creditors, because every resolution applicant wants the plan to be approved. And the people who are deciding on the plan are the financial creditors. So the resolution applicant will structure the plan in such a way that it is very enticing for financial creditors. And in the process, he will keep nothing apart for operational creditors. So the law says that even though you might give whatever you want to the financial creditors, as far as the operational creditors are concerned, you have to give them at least what they would have got had the company gone into liquidation. So the operational creditors should not be worse off because of the greed of the financial creditors. So that is one of the, a very well thought out rationale, which is, captured in the insolvency code in section 30, subsection 2. The next content of a resolution plan is the amount due to operational creditors under the resolution plan to be given priority in payment to the FCs. So in terms of time, the operational creditors have to be paid first before financial creditors are paid. I don't know if there is any benefit out of this section. I mean, eventually everybody will get paid whatever is due to them. But for some reason, the IBBI thinks that they should be paid prior in time. The next prereq is statement as to how the RA has dealt with the interest of all stakeholders, including financial creditors, operational creditors, corporate, so and so. I think this is self-explanatory. A plan obviously has to provide with how all creditors will be dealt with. There is no rocket science here. Then payment to financial creditors who do not vote in favor of the RP of the plan. So there is also a requirement in the plan that dissenting financial creditors must also be paid whatever would be owed to them in case of a liquidation. Similar to the provision that you saw in regard to OCs, there is a similar provision in respect of dissenting financial creditors. And one of the changes in the code has been that previously, if a financial creditor did not vote in the COC meeting, its voting share was not counted at all. So the passing share would then come down. So essentially, previously, whether or not a plan was approved was determined on the basis of the COC members present and voting. Now the regulations have changed. And now if a member does not cast its vote, its voting percentage is considered to be a negative vote. So now, there is a change. So therefore, it has become very important for COC members to cast their vote, because if they don't cast their vote, it will be perceived to be a negative vote. And the voting percentage required for approval of the plan will then, become even more challenging. The next point is term of the resolution plan and its implementation schedule. Now, there are some judgments around this. Various tribunals, NCLTs and NCLT have held that the term of a resolution plan must be reasonable. So, for instance, a resolution applicant cannot propose a plan where he says that I will pay 100% of the outstanding dues of the creditors, but I will pay them over a period of 50 years. The NCLT said this is wholly unreasonable. It has to be a viable plan, and you have to pay them in a reasonable time. So there are judgments to that effect as well. Then how will the resolution applicant manage and control the business of the corporate debtor during the term? So once the plan is approved, there could be a period of 2 months or 3 months before the closing date. So very often in financial transactions, there is a closing date. The closing date is the date on which the entire transaction comes to its logical conclusion. So what will happen between the plan approval and the closing date? The plan must provide. And finally, adequate means for supervising its implementation. Now, the insolvency code says that a plan must be capable of being supervised. What does that mean? What it means is, once the NCLT approves the plan, somebody has to monitor its implementation. Somebody has to ensure that whatever was written in the plan is being implemented. Who does that? So what the resolution applicant does is, in its plan itself, it provides for constitution of a monitoring committee. And that monitoring committee's task is to oversee implementation. So the monitoring committee files routine reports with the NCLT and says, which basically a checklist, saying that the resolution applicant has paid all financial creditors, check. It has paid all operational creditors, check. It has paid all workmen 2 years prior wages, check. It has all other obligations have been fulfilled, all permissions have been obtained. So a plan must provide for this monitoring mechanism. The next mandatory content of a plan is addressing the cause of the default. Now, a company might have gone into insolvency for various reasons. For instance, one of the reasons that the company went into insolvency is that it had leveraged too much debt, and it was not able to service that debt. A resolution plan that says that the company will take more debt to continue its operations is obviously not a feasible plan, and it does not address a cause of default. So it must make business sense, and it must not continue to, because otherwise, if the former promoters could have run the company by taking more debt, they would have continued to do so. What has insolvency achieved for the company? So it must address the cause of the default. The plan must be feasible and viable. That is, it must make business sense. And who decides what is feasible and viable? The committee of creditors decides by way of casting its vote in the COC. what is called the commercial wisdom of the COC. Then next, it must contain provisions for effective implementation of the resolution plan. I just dwelt with this in the past slide. It must include a statement giving details if the resolution applicant or any of its related parties failed to implement or contributed to failure of implementation of any other resolution plan. So if I am a resolution applicant and I have in the past submitted a plan and not implemented it, or I failed, or I sort of contributed to the failure of any other resolution plan, then I must make that disclosure. Then it must have provisions for approvals required for the time and the timelines for the same. So very often a resolution plan is premised on, for instance, certain approvals coming from authorities. Let me give you an example. In one of the cases that I was doing, the corporate debtor owned a factory. That factory was on a leased piece of land in an industrial park. Now, the lease that the factory they had executed with the lessor says that any transfer of lease or any change in the beneficial ownership of the corporate debtor can only take place pursuant to approval of the lessor. So in this case, even though the resolution plan is approved, a formal approval of the lease is required. So the resolution plan must state that how will I get this approval and in how much time will I get this approval. And then finally, resolution applicant's capability to implement the resolution plan. So a resolution applicant is expected to provide two things. One is the financial wherewithal. Show that it has therefore it essentially has to show that if the plan involves a payout of 400 crores, it must show that it has the ability, it either has 400 crores in its accounts or it has the ability to raise 400 crores. So one side is they must show the financial wherewithal. Secondly, they must show that on the management side, they have the right set of people and the right set of skill to revive this company. So if you actually peruse the resolution plan, you will find one part that deals with financing, and you'll find another part where the CVs and the profiles of all the senior leaders of the resolution applicant will be mentioned along with their experience. Now, while I told you that the law does not provide how a plan should be structured, there are some expectations from a resolution plan. And these again come from section 30 and also from the attendant regulations. For instance, the resolution plan must provide for transfer of how the resolution applicant will transfer the assets of the corporate debtor to one or more persons. Now, every resolution plan will obviously involve somebody taking over the assets. Now, who is the entity which will take over the assets of the corporate debtor? How will it do it? Will it keep all these assets with itself, or will it give it some of these assets to its subsidiary to run them? All those things have to be provided in a plan. Next, the sale of all or part of the assets, whether subject to any security interest or not. So if the resolution applicant intends to sell any of these assets, what it intends to sell, how it intends to sell them, and whether there is already a security interest of lenders on the assets has to be stated. The substantial acquisition of shares of the corporate debtor or the merger or consolidation of the CD with one or more person. I think I just mentioned this. It is possible to merge the corporate debtor with the RA or with its subsidiary or a step-down subsidiary or any other company. Then cancellation or delisting of any shares of the corporate debtor, if applicable. This is very important. Many a times, the company that is undergoing insolvency or the company that is being resolved is listed on the stock market. This company already has shareholders. Now, what happens once a plan is approved? Once a plan is approved, even if it is a listed company, that company no longer belongs to its shareholders. The company now is the property of the resolution applicant. So what happens to the shares held by these shareholders? The answer is the resolution plan has to provide that these shares will stand cancelled, and if they are listed on a stock market, how they will be delisted from the stock market. And even if the company is not a listed company, it is privately held, there is always a provision regarding extinguishment of shareholding. So what happens is, once the resolution applicant takes over the corporate debtor, the existing shares which are held by the existing promoters stand extinguished, and new shares will be issued by this company to the resolution applicant. Lastly, curing or waiving of any breach of the terms of any debt due from the CD. Now, almost every resolution plan that I have seen involves waiving of some breaches or debt due. If the corporate debtor were healthy and able to pay all its debts, there was no occasion to take it into insolvency. The whole reason why it is going into insolvency is because it is unable to pay its debts. So the resolution plan must provide that, and most resolution plans state that upon approval of the resolution plan and upon payment of all amounts mentioned in the plan, all debts owed by the corporate debtor to various lenders will stand extinguished. In the absence of this is what is called the clean slate doctrine, because the resolution applicant acquires what is a company that is absolutely clean, free from any liability, free from any debts. Otherwise, I mean, who will acquire a tainted company with all its debts, with all its problems? So that is the clean slate doctrine in operation. I think point one I've already covered, reduction in the amount payable to creditors. The resolution plan should also include extension of maturity date or change in interest rate or other terms of the debt due. So while the resolution applicant can in one sweep say that all these debts will stand extinguished, it is also possible, there are times when lenders tell a resolution applicant that we will approve your plan only if you pay us, some certain debts in a certain manner. For instance, there could be certain non-convertible debentures or other debt instruments which the lenders will not agree to extinguish. So in such case, the resolution applicant will have to extend their maturity date or offer to pay a lower interest rate or any other benefit. So that also has to be included in the plan. Then very often the resolution applicant will acquire a corporate debtor and say that I will, even though the corporate debtor was in business A, I will use all its infrastructure, all its people to carry out business B. So in order to do that, it is essential to change the articles of association of the company. So those changes would again have to be brought about. For instance, you notice during COVID that a large number of units manufacturing sugar started to manufacture hand sanitizer, because producing high purified alcohol requires the same infrastructure that is required to produce sugar. So I mean I think that's just one example of how the same equipment can be used to achieve different ends. Issuance of securities of the corporate debtor for cash, property, securities, I think I'll skip this. Change in portfolio of goods or services produced or rendered by the CD. So if the CD is an automotive parts manufacturer, it is producing, electronic equipment for cars, and the resolution applicant intends to use the factory to manufacture, clutch or gear components, then all that has to be provided within the plan. Change in technology used by the corporate debtor, I think this is self-explanatory, and obtaining necessary approvals from various governments or authorities. What is the treatment of stakeholders under the resolution plan? Now, as I pointed out, the COC is essentially the mother of the entire CIRP process. However, once the CIRP fails and liquidation commences, this entire responsibility then passes on to the liquidator, who then tries to run the whole process under the supervision of the stakeholders. Now, what is very critical to note is the difference between the COC and the stakeholders committee. While the COC effectively runs the process, it also has the right to basically give directions to the COC of how to run the process. But the stakeholders consultation committee is only an advisory body to the liquidator, and the liquidator is not obligated to accept the recommendations of the stakeholders consultation committee. Now, so Regulation 31A was introduced by there was a 2019 amendment to the IBBI liquidation process regulation. What this amendment does is it defines consultation committee as the stakeholders consultation committee constituted under Regulation 31A. And essentially, the 2019 amendment introduced this regulation focusing on the committee in the liquidation process. And according to this amendment, the liquidator is mandated to constitute this stakeholders committee within 60 days from the commencement of liquidation. Now, there's this one decision in the case of creditors of SRs versus Satish Kumar Gupta, which becomes relevant in the context of the issue that we're discussing. Now, I'll very briefly tell you the facts of this case. SR owed a significant amount of debt to creditors and was admitted into insolvency. Now, during the insolvency proceedings, two resolution applicants submitted their bids, that is ArcelorMittal and a company called New Metal. The COC accepted the ArcelorMittal bid. And in this bid, even though the financial creditors were given a good payout, the operational creditors were basically receiving nothing. So the operational creditors who had been left out challenged the decision of the committee of creditors before the NCL80. Now, the NCL80 upheld ArcelorMittal's resolution plan and modified the distribution of the amounts so that all creditors were treated at par. Finally, this matter reached the Supreme Court. Now, the Supreme Court, the issue that came up before the Supreme Court was whether operational creditors could be included in the distribution of proceeds alongside financial creditors. Were they almost on the same pedestal or not? So the Supreme Court said, no, they are not on the same pedestal. So the first thing the Supreme Court does is it upholds Section 53 of the IBC. Section 53 is basically the waterfall mechanism, which is the distribution of funds in case of a liquidation scenario. So the Supreme Court said there is nothing wrong with the waterfall mechanism. And all that the waterfall mechanism does is that it affirms the hierarchy where it places secured creditors above the operational creditors and above the unsecured creditors. So basically what this judgment does is it ensures orderly settlement of claims in liquidation proceedings under the IBC. And while the judgment says that there is need for further reform in the insolvency scenario, it basically what it does is that it says it upholds the IBC and says that you can treat different creditors differently, but you can't treat creditors falling in different classes similarly. And it basically reinforces the power of the COC under the IBC and emphasizes the need for transparent decision-making process while the decisions being taken by the COC and the stakeholders are concerned. Now, coming to the next part, who is a resolution applicant? So far, we've been discussing a resolution plan. Next, we come to is who is a resolution applicant. Now, a resolution applicant means any person who submits a resolution plan. The definition of person is very wide, and it does not only mean a natural person. It can also mean a corporate entity or an incorporated entity. It could also be a person. Now, who can submit a resolution plan? Can only one person submit a resolution plan? The answer is clearly no, because Section 525, which is on your screen, itself says that a resolution applicant is somebody who individually or jointly submits a plan. So a resolution plan can be submitted either by one individual or by two or more individuals collectively, or by one company, or by one or more company collectively. It could also be submitted by 3 companies and 2 individuals. So there is absolutely no restriction on who can submit a resolution plan. The only thing is that for the plan to be approved, it has to meet the test of the commercial wisdom of the COC. If the COC thinks it is a good plan, the NCLT will accept that plan. Now, a very important part of the insolvency code is Section 29 capital A. That is to say, who are the persons who are not eligible to submit a resolution plan? Now, Section 29 capital A was not originally in the code in 2016. When the code was legislated, it was brought in much later in November 2017 by way of an amendment. Now, the idea was to keep people who are unscrupulous or people who are already associated with the corporate debtor out of the resolution process. Because what was happening was the same promoter who was running the company, who had run the company down the ground and into insolvency, was now coming up and suggesting a resolution plan. and the COC had no option but to accept this resolution plan in the interest of revival of the corporate debtor. So this was brought in to ensure that such people are kept out of the resolution process. Now, there are various requirements that are provided in the code under 29A as to who cannot submit a resolution plan. So firstly, a person who is an undischarged insolvent cannot, obvious reasons, submit a plan. A person who is a willful defaulter in accordance with the RBI guidelines cannot submit a plan. A person who at the time of submission of the resolution plan has an account which is an NPA can obviously not submit a plan. So a resolution applicant that has been classified itself as a non-performing asset cannot be trusted to revive another sick company. So it is obvious that such companies should be kept out. A person who has been convicted of an offense punishable with imprisonment for 2 years or more cannot be permitted to submit a resolution plan. Now, there are certain exceptions that are provided, which I will deal with later. For instance, in case an individual is sentenced for 2 or more years, he can submit a resolution plan after a lapse of 2 years of his prison sentence. So if he was sentenced for, say, 7 years, after the 7 years end and another 2 years lapse, he is then eligible to submit a resolution plan. So this disqualification is not absolute. Then any person who is disqualified to act as a director under the Companies Act cannot submit a plan. You might have studied in company law. The ROC exercises its power to hold that certain person are not qualified to act as director. For instance, if you are on the board of a company and that company does not submit its financial results for a certain period of time, then you can be disqualified from acting as a director. So that disqualification also extends to the IBC. Then a person who's been prohibited by the SEBI from trading in securities, obviously, I think that's a no-brainer. A person who's been promoter or in the management or control of a corporate debtor in which avoidance transactions have taken place. Now, this is important. This is again an IBC created disqualification. If I could be a director in a company where certain transaction took place, which transactions were labeled as preferential by the NCLT, then I cannot either individually or through that company submit a resolution plan. Next, any person who has executed a guarantee in favor of a creditor in respect of a CD, which an application for insolvency resolution made by such creditor has been admitted and the guarantee has been invoked and remains unpaid. So if I am a guarantor and my guarantee was invoked and I have not paid that guarantee, then again I'm disqualified. And then if I'm a person who has a connected person who's covered or disqualified under the above clauses, I'm obviously ousted. So these are just a quick list of who's disqualified. And I've read out all of these to you, so I think I can skip this. These are again the exclusions that I pointed out. So in case of financial entities such as banks are exempted, this part on the left bottom about expiry of 2 years from the date of release, in case of an individual I've dealt with, avoidance applications against I've dealt with, so I think I can skip this. Now, the next judgment that I want to deal with is ArcelorMittal. Because this judgment is actually the first judicial pronouncement that explains the applicability of Section 29 capital A. Now, what happened in this case was that NCLT and NCLAT had rejected 2 resolution plans for SR Steel from 2 different resolution applicants on the grounds that they were ineligible under Section 29A. Now, one of the resolution applicants, that is ArcelorMittal, was ineligible on account of one of its connected parties being a promoter of a corporation that held an NPA account. So ArcelorMittal had a sister company, which was the promoter of a company which had an NPA account. And the other resolution applicant was ineligible because its shareholders were promoters of the corporate debtor, and the corporate debtor itself was an NPA account. So both sides had an NPA angle. So the issues that came up before the Supreme Court was whether the stage of ineligibility of the resolution applicant when does what is the date of reckoning? At what date will the court have to see whether the resolution applicant was barred by 29A or not? That was the first question. The second question was whether the resolution applicant can challenge the rejection of the resolution plan. So the Supreme Court said that the power of the RP to decide whether the RP does have the power to decide whether the plan does or does not contravene the provisions of the law. And then the Supreme Court says that the 29A validity, whether the applicability of 29A applies to a resolution applicant or not, has to be seen on the date the plan was submitted, not later, not previously. So this is a very important decision in the context of a resolution applicant. I think I will just, in the interest of time, just go through this quickly. Now, there is a very interesting exception to Section 29A, and that is Section 29A. Some provisions do not apply to MSMEs, and I hope you know what MSMEs are. They are medium or small or medium scale industries. Now, this exception was also brought in by way of an amendment in 2018. And Section 240 capital A clearly says that clauses C to H of 29 capital A shall not apply to the resolution applicant in cases of MSME. Now, the rationale that has been provided for excluding MSMEs is actually contained in a report that was prepared by the Insolvency Law Committee. And the report basically explains that MSMEs are the bedrock of the Indian economy. And therefore, the intent is to resolve their insolvency rather than push them into liquidation, because doing that will affect the livelihood of its employees. And the report says that the MSME is such a small entity that its business will probably not be of interest to anyone else. And therefore, its promoters are the only people who are interested in reviving it. And therefore, it is best to not exclude these promoters from the revival process. So I think in the interest of time, I will skip this judgment. I'll come to the next slide. I think I've already dealt with this issue. What is the stage at which 29A is attracted? So ineligibility has to be checked at the time of submission of the plan and not on the date on which CIRP commenced. Ineligibility can be cured in case the ineligibility pertains to non-payment of certain debts, etc. Then the ineligibility is curable. And the person who has been a promoter or in the management or control of the corporate debtor in which the avoidance order has been passed is ineligible to submit the plan. I think this I can skip. I've already dealt with ArcelorMittal.
Sir, all these cases belong to which year?
They're mostly recent cases. Some of them are as recent as 2023,
Okay.
but mostly to, between 2018 and 2023.
Okay.
I can share the citation with you if that interests you.
Yes, sure, sir.
Great. So one more judgment that I wanted to deal with you is this case called Punjab National Bank versus Concord Hospitality. Now, this was a case where a resolution plan was submitted by the promoter of a corporate debtor. And this was an MSME. But the COC held, COC's decision was that the promoter was ineligible to submit a resolution plan because the corporate debtor had been previously classified as an NPA, and more than 1 year had elapsed after this classification. The other major objection was that the resolution applicant had furnished a personal guarantee in favor of two banks to secure the debt of the corporate debtor. And therefore, it said because he's already submitted a personal guarantee, he is therefore ineligible. So in this case, NCLT Chandigarh held that prior to the amendment to 29 capital A, a person was debarred to submit a resolution plan if this person had executed an enforceable guarantee in favor of the creditor. But in the amended section, the 29AH, the person eligible is only the one who's executed a guarantee in favor of the creditor, and this guarantee was not paid in full or part. Therefore, simply because the resolution applicant has furnished a guarantee will not make him ineligible. Next is who is a connected person for the purposes of 29A. Basically, a person who's connected to the persons as defined in the explanation shall be disqualified. So, for example, if A wants to submit a resolution plan for B Limited, A proposes that C shall be in the management of B Limited during the implementation of the resolution plan. However, C is a person suffering disability under 29A. So therefore, A becomes ineligible to submit the resolution plan himself. Next, we come to who's a related party. So section 524 basically provides for the definition of related party. However, the expression related party describes what can be best described as a commutative relationship. That is, X can be a related party of Y if either X is related to Y or Y is related to X. It cannot be argued that X is not related party to corporate debtor if corporate debtor falls in the definition of related party with reference to X. So, I mean, this is something that, you actually have to figure out by way of computation yourself. I mean, it's you read a couple of judgments and then you'll probably understand what the related party concept, how it plays out. I have a couple of judgments with me. And we are almost go through them or instead. Shruti, what do you suggest? You want me to go through them with 3 or 4 more judgments?
So your voice is, I think,
Can you hear me now?
yes, sir.
So I'm saying there are 3 or 4 more judgments.
Yes,
I
sir.
think I should, because we're almost done with an hour, I think I'll send these to you
Okay, sir.
rather than discussing them. And I'll just come to the last
Okay.
slide, the role of RP and COC.
Sure.
So, I mean, as you would probably have gathered from my presentation, the code itself has undergone various amendments over the past couple of years, and so have the regulations to clearly lay down the role of RP and the COC. And the Supreme Court, Supreme Courts as also other courts have, provided in various judgments, they've provided a lot of clarity and direction on the role and duties of the resolution professional when he's examining each resolution plan under section 32. Now, what the resolution professional has to do is he has to confirm the eligibility and form a prima facie opinion that the resolution applicant is well within its right to submit the plan. 2, that it is not barred by 29 capital A. And 3, that the plan is in compliance with the Insolvency and Bankruptcy Code and meets all the requirements that are laid down in section 30. And once the resolution professional does all of this, it is only then that he can actually submit the plan for voting by the COC. And the COC, of course, in its wisdom, even if it feels that all these tests are met, it can still reject the plan, because at the end of the day, the underlying basis of the insolvency code is the commercial wisdom of the lenders. And so what the resolution professional, the role of the resolution professional is limited to providing a prima facie opinion on all provisions of the law having been met, including section 29 capital A. And, the Supreme Court, with a view to protect the RP, has also said that it is even acceptable if the RP wants to append a due diligence report in respect of all of its findings, because, the RP very often cannot take all these decisions himself. So he will very often engage experts or consultants who will prepare a report. For instance, in case of an avoidance transaction, the RP engages an expert firm to carry out a forensic audit and then files avoidance applications on the basis of the report prepared by the forensic auditor. Similarly, in other issues also, the RP is well within its rights to engage a consultant and prepare a report and submit those reports along with its application for approval of the plan or anything of that sort. So I think that's the long and short of my presentation. I've stuck to my time. If you have any questions, you can ask them now or you can email them to me. And subject to Achal being okay, I'm very happy to share my presentation or anything, or the judgments or the notes or anything that you might need.
Sir, if
Right?
you could please provide your mail ID in the chat box.
Yes, I will. And I'd be happy to, if you need any clarity or any guidance on the code, just feel free to reach out to me. I'll be happy to support you in whatever way I can. I mean, this is a way of sort of giving back to sort of the legal fraternity. So, I mean, please feel free to reach out. I'd be happy to provide you any support that you might need.
Thank you, sir.
Thank you so much, Riddhi. Thank you. Lovely, lovely,
So,
lovely meeting you.
sure. Same here, sir.
Thank you. Bye-bye.
Bye, sir.